Good evening, everyone. On behalf of Passaic County Prosecutor Camelia Valdez, welcome to the Passaic County Prosecutor's Office's 2121 event on extreme risk protective orders. My name is Chief Assistant Prosecutor Mary Catherine Ryan, and I will be serving as moderator this evening. As part of the Attorney General's 21 County 21st Century Community Policing Project, today's discussion on extreme risk protective orders, or ERPOs, hopes to build on and strengthen relationships between law enforcement and communities within Passaic County. You are welcome to submit questions or feedback through the chat, and we will provide an email address where you can contact us after the event. The ERPO Act was signed by Governor Murphy in June 2018 and went into effect on September 1st, 2019. Shortly before the law's effective date, former Attorney General Grewal issued Attorney General Law Enforcement Directive 2019-2, known as the Extreme Risk Directive, that implemented the law and provided guidance to New Jersey's 38,000 law enforcement officers on seeking orders under its provisions. The ERPO Act created a process through which a family or household member or a law enforcement officer can apply for a court order against a person who presents a significant danger of bodily injury to self or others by possessing or purchasing a firearm. The issuance of such an order, known as an ERPO, prohibits that individual from possessing or purchasing a firearm or ammunition and from holding any firearms identification cards or permits. As of 2020, 19 states and the District of Columbia have passed similar red flag or extreme risk laws. As of September 2021, a total of 726 ERPO petitions have been filed overall in New Jersey. Of those, courts have granted 664 temporary ERPOs, and of those temporary ERPOs, courts have granted 325 as permanent or final ERPOs. ERPOs present another opportunity to intervene in crisis situations where a person poses an extreme risk to self or others by having access to firearms. An ERPO can be used as a tool when a domestic violence order can't be issued, maybe because there is no act of domestic violence or no domestic violence relationship, or when criminal charges are not appropriate because no crime has been committed, or when a person poses a danger only to themselves. Today, we would like to share with you information about the ERPO law and how it impacts our communities in Passaic County. To aid in explaining some of the aspects of ERPO, I am pleased to introduce you to this evening's panelists. Chief Assistant Prosecutor Giselle Da Silva, Senior Assistant Prosecutor in Charge Peter Foy, and Senior Assistant Prosecutor Brian Fiorello. Chief Assistant Prosecutor Giselle Da Silva joined the Passaic County Prosecutor's Office in 2001 and presently oversees the Domestic Violence Unit. She has also served within the Special Victims Unit and the Juvenile Unit. As supervisor of the Domestic Violence Unit, she oversees the handling of over 1,800 criminal cases and family court contempt matters. She also regularly trains police officers and staff regarding domestic violence procedures and presents on topics related to domestic violence, such as elder abuse and domestic violence and its effect on pregnancy. She is an adjunct professor at William Patterson University and instructs criminal investigation to college students. Prior to joining the PCPO, she clerked for Judge Gaeta and Judge Sullivan in Bergen County. She is a graduate of Montclair State University and Pace University School of Law. Peter Foy is a Senior Assistant Prosecutor with the Passaic County Prosecutor's Office since January 2016. Senior AP Foy is certified as a criminal trial attorney by the Supreme Court of New Jersey, and he presently oversees the Public Integrity Unit, which handles internal affairs and government corruption cases throughout Passaic County. He has also served the office in the Trial Division and the Speedy Trial Unit. Previously, Mr. Foy served as a supervising assistant prosecutor in the Morris County Prosecutor's Office, where he worked for 13 years. He served there as the supervisor of the General Investigations Unit and also served in the Megan's Law Unit, the Fraud Unit, the Insurance Fraud Unit, Sex Crimes Unit, and Major Crimes. Peter has also worked in the Essex County Prosecutor's Office, where he served in the Screening Unit, Juvenile, and Trial Unit. Previously, he served as a law clerk to Judge Rothenberg in Passaic County. He is a member of the New York and New Jersey bars, and he is a graduate of Marist College and Seton Hall University School of Law. Senior Assistant Prosecutor Brian Fiorello has been a member of the Passaic County Prosecutor's Office since 2003. He is presently a senior assistant prosecutor assigned to the asset forfeiture unit and is responsible for reviewing hundreds of petitions for expungements, applications to carry firearms, appeals for denials of firearm purchaser identification cards, and ERPOs. He has previously been assigned to the juvenile, domestic violence, pre-indictment, grand jury, drug court, and trial units. Prior to joining the PCPO, he clerked for Judge DeLucia in Passaic County. He is a graduate of Susquehanna University and Seton Hall University School of Law. As for myself, during my time in the Passaic County Prosecutor's Office since 2009, I have served in the domestic violence unit, pre-indictment and grand jury units, and trial unit. I previously oversaw the public integrity unit and presently oversee our asset forfeiture unit, which handles numerous types of cases, including ERPOs. I'd like to begin the discussion this evening with Giselle, who will lay out some common terms that you'll be hearing and the major concepts behind obtaining an ERPO.
Thank you, Mary Kate. Welcome, everyone. We go to the next slide, please. Thank you. I want to define for you some of the terms that you're going to hear during tonight's presentation. Beginning with the term ERPO, it stands for Extreme Risk Protective Order. That is the order that we are speaking of tonight, but it comes in different terms and it comes in different methods. The example is a TERPO. TERPO is a temporary extreme risk protection order. A FERPO is a final extreme risk protection order. You will hear these terms interchangeably throughout tonight's presentation, but they are all relating to the ERPO itself. A petitioner, that is the person who is filing for the ERPO. So in other words, the petitioner is the person who is asking for an ERPO to be granted. The respondent is the person whom against the ERPO is being filed. In other words, it is the person who the ERPO is against. Next slide. The purpose of this program is to inform the public of what ERPOs are and what are other options. Can you go to the slide before, please? Thank you. If an individual expresses to the police that they believe that another person poses an immediate and present danger of causing bodily injury to themselves or others by having custody or control of, or having access to, or owning, possessing, purchasing, or receiving firearms, they are the individual who may seek to get an ERPO. When they seek out the police and their advice, the police shall inform them of the ERPO Act and the procedures, including who qualifies as a petitioner. So example, when we say the police shall inform them, we mean the police shall inform the public or the individual seeking the ERPO to see if they actually qualify to obtain one. Next slide. So in continuing with informing the public of ERPOs and other options, we want the public to be aware that ERPO applications may also cover individuals that qualify for a domestic violence restraining order. And likewise, those who wish to obtain a domestic violence restraining order may be better suited to obtain an ERPO. When an individual meets with the police or the court officer asking about getting an ERPO or a domestic violence restraining order, it is best if they are explained what both of them are, and then they can choose if one may seem better than the other. So here's an example. Under domestic violence, in order to obtain a domestic violence restraining order against an individual, they must be a family or household member. There must have been an act of domestic violence. And the restraining order is being sought because it is needed to protect the victim's well-being. So not only under domestic violence are you asking to take away someone's access to a gun because you believe that they may be an immediate and present danger, but you're also asking the court to give you protection from that individual. An ERPO is something that can be sought by a family or household member, but it also can be sought by a law enforcement officer. This is something that the domestic violence restraining order does not allow to happen. Continuing with the ERPOs, there need not be any criminal act, but the individual does pose, or an individual believes that they pose, that to be an immediate or present danger to themselves or others by having an access to a gun. So the ERPO does not provide any protection from contact with the individual, but it provides the protection of removing the firearms from the individual's possession. Slide. So the petitioner, this is the person who can file for an ERPO petition. It can be a family or household member, which means it could be a spouse or a former spouse, present or former household member. So it's someone that they could have lived with in the past, currently, or a former dating partner. You need not be in that relationship. Someone who has a child or they are expecting to have a child in common. But the other person who can get an ERPO is a law enforcement officer. So defining all of these categories and these individuals, a neighbor, a friend, or anyone else cannot obtain an ERPO against an individual. However, a neighbor or a friend can go to the police and provide police with information that they believe would lead to the possibility that a person poses a present and immediate danger, and the law enforcement officer can then apply for an ERPO. Next slide. The respondent, that is the person against whom the ERPO is being filed. In other words, the petitioner is seeking to bar the respondent from having weapons. The respondent can be a juvenile, so we can get an ERPO against a juvenile. And there are special rules if a respondent is a police officer. So yes, an ERPO can be issued against a police officer. Now, the two categories, the juvenile and the police officer, my colleagues will explain those in more detail later in this presentation. Next slide. The petition. So the petitioner, the person seeking the ERPO, can file this petition at the Superior Court or a state, county, or municipal police department. So they can go to the courthouse or to the police department. The rules are different if the individual is a police officer, and again, my colleague will explain that to you. But the ERPO must be filed by police or by a court officer in the same county where the respondent resides. So if you are wishing to obtain an ERPO against an individual, it must be filed where that person lives, not where the person seeking it lives, but where the individual whom the ERPO will be against resides. So if the petitioner comes to the police in a different county, that agency will contact the proper agency, and the ERPO petition can be done over the phone. And the information can also be provided over the phone. So an example, if a party that lives in Clifton is dating an individual that resides in Newark, and they believe that there is a concern, an immediate and present danger with that individual possessing firearms, that person can go to their local Clifton Police Department and tell them of their concerns. The Clifton Police Department would then contact the municipality where that individual lives. Let's say they live in Newark. The Clifton Police will contact the Newark Police and will express the concerns or allow the petitioner to speak directly to the police and express that person's concerns about this individual being an immediate and present danger. Next slide. Obtaining the petition at the police department. The police shall advise the individual seeking the ERPO, the petitioner, for the procedure for completing and signing a petition. The police will then enter the petition into what's called the ECDR. This is the electronic court disposition reporting system that is used by the courts and the police. They will enter the petition for the individual. The police may also assist the family or household members in preparing the petition, including giving some information on the ERPO factors. The ERPO factors will be explained later in this presentation by my colleague, Brian. Next slide. Now, the contents of the petition. They will allege that the respondent poses an immediate and present danger of bodily injury to self or others by possessing, purchasing, owning, or receiving a firearm. The petition will further set forth the facts and the basis of knowledge of danger. So what is it that this petitioner knows? What information have they been made aware of, either by someone else or their personal knowledge? These facts will be placed in the petition. The number, types, physical description, and location of the firearms, the ammunition that the petitioner believes to currently be possessed by the respondent. Now, knowing the type of gun that someone may have It's understandable if you don't know what exactly the make and model of the gun is, and that's fine. If an individual goes to the police and is seeking an ERPO, the police will ask, can you tell me what kind of gun they have? And maybe they'll say, well, it's a long gun and they keep it in the closet in their bedroom. The petition will say, it's a long gun. If the individual says to the police, well, it's a small silver gun that they hold in their hand, the petition can simply say a small silver handgun and where the person believes it is. If the person happens to know, the person being the petitioner, the specifics of the gun, that's great. They will provide that information to the police and they will know exactly what is to be sought. But again, not having the exact description should not stop someone from going to the police and letting them know of an imminent and present danger. This affidavit, the petition, may also reference documents that the petitioner has in their possession. Perhaps they have court documents or medical documentation. Maybe there's a letter written by this individual expressing self-harm or some thoughts that are concerning to the petitioner. They can provide those documents to the police as part of the application on the petition. And also this petition will be sworn and under oath. So the individual that's applying it will be asked to take an oath. Next slide. The law enforcement officer may also be a petitioner. So the police, they can file their own petition, they can join a petition, or they can take over a petition for an ERPO. So here are some examples. The officer will file the petition if they are the original petitioner. So example, if neighbors or friends of an individual or even coworkers go to the police with concerns they have regarding an individual, the police officer can take that information and file a petition for an ERPO. This information was obtained by the officer from the public directly to them, and they will become the petitioner. The officer can also take over a petition that was originally requested by a family or household petitioner and then become the sole petitioner. So an example is if a household member comes to the police and expresses concerns regarding an imminent danger, the police will take the information and begin the petition. If at some point during the application, this household member decides that they don't feel comfortable pursuing this, that maybe they are afraid of retribution, or maybe they physically or medically can't continue on, the police officer can then step in and take over the application. The police officer has now met with this original petitioner, has obtained all of the information that the petitioner has, and they can now take over and proceed as the petitioner without the household member or family member being involved. And the last option is that the police can join in on a petition for an ERPO. An example would be if the family member comes to the police and provides them with information that they believe is concerning regarding a respondent's behaviors, they can start the application with the police. Perhaps the police decide to do an investigation, and maybe they go out and talk to some neighbors or some other friends of this individual, and they on their own independently obtain information about this individual. The police can take that information and then join the petition. So now it is the original petitioner, family or household member, and now the police also as part of this petitioner, and they are joint petitioners. So the ERPO will go before a judge with all of this information contained therein. At this point, I'm going to turn it over to my colleague, Brian.
Good evening, everybody. On the duty to warn section, in addition to the remedies in the duty to warn statute, if an officer receives a duty to warn from a healthcare practitioner, the police themselves may file for a TURPO, as long as there is probable cause to believe that the respondent poses an immediate and present danger of causing bodily injury to the respondent or others by owning, possessing, purchasing, or receiving a firearm. So a healthcare practitioner would be a doctor, a nurse, a psychiatrist, and a psychologist. If they are required to tell the police if someone who they are treating presents a danger to themselves or others with suicidal or homicidal thoughts, should they have any. Those healthcare providers have a duty to call the police, and the police themselves can file for a TERPO. And again, those healthcare providers are obligated to call the police. Next slide. This is the TERPO. A TERPO shall be heard in an expedited manner. The proceeding is recorded, and the venue, or where the case is heard, is in the county where the respondent lives, unless the respondent lives out of state, in which case it will be heard where the petitioner lives. The court may question petitioner or rely on an affidavit that's prepared by the petitioner. Generally, there is no respondent appearance, and there is no requirement for the police or the prosecutor to be present unless the police officer is the petitioner. And again, just to reiterate what we said previously, a juvenile can be the subject of a TERPO. Next slide. ERPO factors. For a TERPO or a FERPO, the court shall consider what is known as the ERPO factors. And the court must determine whether there is good cause to believe that an individual poses an immediate and present danger of causing bodily injury to themselves or others by having custody or control of, owning, possessing, purchasing, or receiving a firearm. In addition to obtaining a TERPO, a court can issue a search warrant if they have probable cause, which is a legal term for meaning reasonable grounds. As a member of the public, you must provide the police with all the information you have in support of your petition to obtain a TERPO, and you must focus on the following ERPO factors I'm about to read to you. Next slide. Number 1, is there a history of threats or acts of violence directed towards self or others? Number 2, is there a history of use, attempted use, or threatened use of physical force against another person? 3, is the respondent the subject of or has violated a temporary or final restraining order issued pursuant to the Prevention of Domestic Violence Act? 4, is the respondent subject of or has violated a temporary or final protective order issued pursuant to the Sexual Assault Survivor Protection Act? 5, does the respondent have any prior arrests, pending charges, or convictions for a violent indictable crime or disorderly persons offense, stalking offense, or domestic violence offense? Next slide. 6, does the respondent have any prior arrest, pending charges, or convictions for any offense involving cruelty to animals or any history of acts involving cruelty to animals? Number 7, is there any history of drug or alcohol abuse and recovery from this abuse? 8, has the respondent recently acquired a firearm, ammunition, or other deadly weapon? And I'll add to that, is there a firearm, ammunition, or other deadly weapon in the residence where the respondent resides? Number 9, has the respondent recklessly used, displayed, or brandished a firearm? Number 10, is there an existing or previous extreme risk protective order issued against him or her? And number 11, has the respondent previously violated an extreme risk protective order issued against him or her? Next slide. If the court finds one or more of the previous factors I just listed, then the court may consider additional factors, including whether the respondent, 12, has any prior involuntary commitment in a hospital or treatment facility for persons with psychiatric disabilities. 13, received or is receiving mental health treatment. 14, complied with or has failed to comply with any mental health treatment. And 15, has received a diagnosis of a mental health disorder. And I'd like to use right now an example of how those factors could work in New Jersey. And I'm going to read a little piece of an article. On Tuesday, a teacher found a note on Ethan's desk and took a photo. It was a drawing of a gun pointing at the words, "The thoughts won't stop. Help me." There was also a drawing of a bullet with the words above it, "Blood everywhere." Between the gun and the bullet was a person who appeared to have been shot twice and is bleeding. "My life is useless and the world is dead" also were written. Now, these were the facts of the case that happened in Michigan around a week ago, where there was a shooting at the school and a number of students died. If this happened in New Jersey, the school would have called the police. The police would have considered a TERPO, conducted an investigation, filled out an affidavit under factors 1, 2, and 8. And remember the factors I read to you before. Their investigation would have found out that the student's father or mother had purchased a handgun 4 days ago. That's why number 8 would have been present. And almost 100% a TERPO would have issued, along with a seizure warrant, and the firearms would have been removed from that home. So that's how those factors play in a real life situation when you present them to the judge. Next slide. Providing information at the TERPO stage. The court is going to consider the following information in addition to determining whether or not to issue a TERPO. Criminal or juvenile history, driving history, what's known as a DVCR inquiry. That's a domestic violence central registry, where they will look to see if there are any domestic violence restraining orders or any other ERPO orders and violations. They will look to see if the respondent is registered in the Sexual Assault Survivor Protection Central Registry. And they will provide to the court any additional information that the police or our office has readily available and is relevant to the ERPO factors I read before. If the petitioner is a police officer, then statements, reports that the officer is relying on will be provided. In addition to the factors I told you, they will also do a search of what's called the firearm index for the respondent or anybody else who lives in the respondent's home, to see if anyone in that home has firearms registered to them in determining whether or not to get a TERPO. Next slide. Serving the TERPO. After a TERPO is issued by the court, it will be forwarded to the county prosecutor and the police where the respondent resides. The police where the respondent resides shall serve the TERPO on the respondent immediately or as soon as is practicable. An example of that will be if the respondent is in the hospital, they're not going to go serve a respondent who we can't get to, and they may have to wait a couple of days till the respondent gets out of the hospital. A TERPO and a FERPO will remain in effect until further order. There is no automatic expiration of a TERPO or a FERPO. Once issued, they will stay in effect until further order of the court. The TERPO order itself will give notice to the respondent of the date and location of the FERPO hearing. Next slide. Search warrants. If there is a search warrant with the TERPO order, and again, there must have been probable cause, the police where the respondent resides shall execute the search warrant immediately or as soon as possible. The police shall seize all firearms and ammunition within possession, custody, or control of respondent, including weapons belonging to someone else if respondent could have access or possess the weapons. In other words, if there are guns in the home, the police will seize them even if the guns belong to someone else in the residence. The key is to present access to firearms to respondents other than the ERPO. In addition, any information obtained when executing that search warrant can be used at the later FERPO hearing. Next slide. FERPO. A FERPO is where the TERPO is made final, and the FERPO shall be scheduled in the Superior Court 10 days after the TERPO issues or is served. It is heard in the same county as the TERPO, and at this stage, the respondent has a right to be present, have an attorney, present documents, and supply witnesses. The courts will again consider the factors which I read previously, and the standard changes a little bit. It is whether by a preponderance of the evidence at the hearing, or more likely than not, the respondent poses a significant danger of bodily injury to the respondent's self or others by having custody or control of, owning, possessing, purchasing, or receiving a firearm. The prosecutor only has to appear at a FERPO hearing when the police officer is the petitioner. That means if the police officer is the original petitioner, he takes over the petition or joins the petition. Remember, these are civil matters. If there are no police, the petitioner is going to be by himself or herself. Next slide. Providing information at the FERPO stage. Again, the police shall produce any available evidence, including evidence related to the factors to the court to consider. This evidence will be considered at the FERPO hearing, so it needs to be provided to the court prior to that hearing. Next slide. And appeals. If a TERPO is denied by a municipal judge, the petitioner can request an immediate review hearing over the phone to the on-call Superior Court judge. The police, if it's the police, they can call the on-call Superior Court judge. If a TERPO is denied by a Superior Court judge, the petitioner can file an appeal to the appellate division within 45 days. A FERPO granting or a FERPO denial. Either a petitioner or respondent can appeal a decision by the Superior Court judge to the appellate division within 45 days. Next slide. I'm now going to hand this over to Peter to talk about what happens when the respondent is a police officer.
Thank you, Brian. So what happens when the respondent is a police officer? What happens when a person seeks an extreme risk protection order against someone employed as a law enforcement officer in New Jersey? When that occurs, a different procedure must take place under our law. First of all, the petition can only be submitted to the law enforcement agency that employs the respondent officer. So if the respondent works for the Springfield Police Department, the petition must be filed in Springfield. The petition must be filed on paper. It is not electronically filed in the electronic court disposition reporting system as a traditional ERPO application would be. This does not mean that the complainant must travel to the agency that employs the respondent. If someone files a complaint for an ERPO against a Newark police officer with the Camden Police Department, then Camden would take that paper application and send the copy to Newark. Whenever an employing law enforcement agency receives an ERPO petition against one of their officers, they must provide a copy to the county prosecutor's office immediately. The next step after receiving that paper petition is the agency must commence an internal affairs investigation into the respondent officer. This investigation must be completed within 48 hours. Normally, an internal affairs investigation can take up to 45 days, if not longer. This investigation may be referred to as an expedited ERPO internal affairs investigation. During the course of this expedited ERPO investigation, the agency will review the paper petition. They may interview the person who filed the petition or any other witnesses with knowledge about the officer. They should review the internal affairs file and the employment history of the officer. And they may consider any of the other ERPO factors that they are aware of regarding the officer. As with any internal affairs investigation, this process is confidential, which can help protect the identity of the petitioner, the reputation of the officer, and the integrity of the investigative process. Once this expedited ERPO investigation is completed, it is forwarded to the county prosecutor. The county prosecutor will receive all the investigative materials and a conclusion or recommendation from the agency. That is, whether the agency feels there should be an ERPO against the officer or should not be, and why. The county prosecutor then has one business day to make a decision, whether or not to file for a TERPO against the police officer. The county prosecutor will file for a TERPO when there is probable cause to believe the respondent officer poses an immediate and present danger of causing bodily injury to self or others by possession of a firearm. When a county prosecutor files for a TERPO against a police officer, Then a detective with the county prosecutor's office becomes the petitioner. This is similar to when a law enforcement officer takes over as petitioner from a civilian in a regular ERPO application. But here, the prosecutor is taking over as petitioner for the local law enforcement agency. At this point, the ERPO is electronically filed by the prosecutor's office. The petition is no longer just on paper. If the prosecutor does not choose to file for an ERPO, the notice is given to the original petitioner as well as the target officer. There may be times where the employing agency is so concerned about the officer having access to firearms before or during the ERPO investigation that they take action. If there is probable cause to believe that the presence of firearms would expose the officer or others to a risk of bodily injury, then the agency that employs the officer can order the seizure of all of his or her firearms. That includes firearms issued or authorized by the agency, as well as any personally owned firearms. Again, if the employing agency deems it appropriate, this action can be taken at any time before or during the expedited ERPO investigation. The employing agency would seize all firearms possessed by the target officer. Service-issued firearms are then stored or held by the employing agency, and any firearms the officer personally owns are stored by the county prosecutor's office for safekeeping. Now, Mary Kate, it's my understanding that the way firearms are stored during a standard ERPO application is a little different. Is that correct?
Yes, that is correct, Peter. You spoke about what happens if the respondent is a police officer, but in a non-police case, as Brian mentioned earlier, if the police have a search warrant to retrieve weapons from a home or from a person, they will take possession of those weapons. And what happens from that point is that all firearms or ammunition that are seized are sent for storage according to the policy of the prosecutor's office or the county where the ERPO is venued. For all state police seizures, it's the county prosecutor's office of venue that will store. If there's someone other than the respondent who can claim lawful title to that firearms or ammunitions, they can provide that documentation to the officer or the police agency that's storing the weapons. And the lawful owner's claim will be reviewed. And if that person is otherwise lawfully permitted to possess those firearms, they can be returned by the police department to that person who's not the respondent. Alternatively, the respondent could request that those firearms or ammunitions be transferred to a licensed firearms dealer. So again, the respondent, him or herself, wouldn't have access to the weapons, but they can ask that they be transferred or sold to a dealer. Once a FERPO is issued and that order is made final, there can be a point of time where either the petitioner or the respondent applies for that FERPO to be dismissed. And that petition for termination of a FERPO can be filed at any time by either the petitioner or the respondent. If a petition for termination is filed, the notice goes to the other party, the prosecutor's office, and the police. There's then a court hearing, and the prosecutor can object and ask the court to consider the ERPO factors that Brian's discussed, any history of past or present mental health treatment, and the petitioner's opinion as to the status of the petition to terminate. If the respondent requests termination, the respondent must establish by preponderance of the evidence, and again, that standard is more likely than not, that the respondent no longer poses a significant danger of causing bodily injury to self or others by owning, possessing, purchasing, or receiving the firearm. If the FERPO is terminated, the respondent can petition for return of the firearms or ammunition, which shall be returned by the prosecutor within 30 days, as long as the respondent is legally allowed to possess those firearms. So the same process that we previously discussed would occur. The police would still review the current status of that person's criminal history, any other factors that might affect their ability to possess firearms. And if everything is satisfactory, then those weapons can be returned. I'm posting at this time an email address where you can contact us after the presentation with any questions or feedback. And that email address is pcpo2121@PasadeCountyNJ.org. And at this point, I'm just going to stop sharing the PowerPoint so that we are able to answer some questions and continue the discussion, but I will revisit with you what that email address is. So, again, if you have any questions, please feel free to submit them into the chat. Peter, you spoke about the different procedure that's used for ERPOs against police officers. Can you explain a little bit about why that procedure is different?
Sure. A different procedure is set up for police officers because they have to be armed as part of their job. If an ERPO is granted against a doctor or a lawyer, they're dispossessed of their firearms, but they can still do their job. Not so with a police officer. There's a court order saying they can't carry a firearm, and they can no longer be gainfully employed as a law enforcement officer. They lose their employment. So what our law takes that into consideration. By this expedited ERPO investigation, the police officer is given a little more due process, but the public is still safeguarded in that the chief executive could seize their firearms if there is that concern.
And Peter, if somebody seeks an ERPO against a police officer, is that petition limited to circumstances where the risk or the danger is related directly to the police officer's job?
No, it can be for conduct in their private life as well, and indeed often is.
Thank you. Brian, we spoke a little bit about what happens to firearms when they're taken and where they're seized and what happens to them if a final ERPO is entered. Can you talk a little bit more about what the options are for a person who possesses firearms or for the police who are in possession of firearms once the FERPO is entered? Brian, I'm just going to ask you to unmute yourself.
Thank you. Thank you. In our county, typically, the firearms are held by the local police departments. And there are three things that somebody who is subject to a FERPO or a DERPO can do once their firearms are seized. One, they can allow the local police department to hold on to them and have them destroyed. Two, they can have them transferred to another person that has a firearm purchaser ID card, as long as our office doesn't object and the court finds that acceptable. Or three, they can have those transferred to a firearm dealer and have them sold on their behalf.
Thank you. Giselle, going back to where we began the presentation at domestic violence, what if someone applies for a domestic violence restraining order, but a judge doesn't grant the TRO? Can that person still seek a TURPO?
Yes, they can. So the individual who sought protection through a domestic violence restraining order can use those same factors and apply for an ERPO. They can go to the police, tell the police the exact same thing that they told the judge, and the police will assist them again in getting the ERPO, or perhaps the police can take some of that information and do some more of an investigation, and they can join in the application with this individual. But yes, the answer is they can. They can also seek an ERPO if they are in fact denied a temporary restraining order, but the protections will be different. If you remember, a restraining order provides you with protection from the individual. The ERPO is to protect the individual from having access to weapons.
Brian gave us an example through the recent Michigan shooting of how an ERPO application process might have played out in New Jersey in a non-domestic violence context. I just wanted to give you, Giselle, a brief hypothetical that might illustrate the overlap or the differences between a restraining order and an ERPO. So for instance, a woman walks into police headquarters and tells the police that she recently ended a 3-year relationship with her boyfriend. Today, her now ex-boyfriend sent her a picture of what she believes is his hand with a gun in it and the comment, "I can't live without you." She knows he lawfully owns guns and is concerned that he may harm himself. The police, knowing the relationship, advise her that she can apply for a restraining order. She states that she doesn't want him to know the information came from her and that even though she's afraid, she doesn't want to go forward with a restraining order. What can the police do at that point?
So after speaking with her and getting that information from her, the police can then become a petitioner on an ERPO. After hearing that this individual has made what appears to be a threat to hurt himself, and it appears that he poses an immediate and present danger to himself and possibly others, but he's expressing, even with that one sentence, that he may harm himself. So with that information, and with hopefully the image that she explained to the police, maybe there's a text message, she can give the police that as well. The police can then act as a petitioner and they can seek an ERPO, hoping to get any lawfully owned weapons away from this individual who's expressing some ideations that he may harm himself.
All right, I'm not seeing any other questions in the chat. And again, I'll reiterate that you are welcome to contact us at any time. We know that this is a lot of information to absorb, especially if you're just becoming familiar with the ERPO process. So please reach out to us at that email address I posted earlier, pcpo2121@PasayeCountyNJ.org, if you have any follow-up questions or feedback after the presentation. Again, on behalf of Prosecutor Valdez, we'd like to thank you all for coming, for your attention, and for your time. This is obviously a very important issue. It's unfortunately playing out in the news every day. It affects us on the national level, the state, county level, and unfortunately sometimes in our home lives. So thank you for paying attention. For those of you who work in the community as social workers, police officers, mental health professionals who have the opportunity to educate people that you may be interacting with about ERPOs, thank you. Thank you for sharing that information. And please know that we're always resources to you, as well as our Victim Witness Advocacy Unit, if anybody is interested in obtaining more information. So with that, I'll thank you again. Please be well, and everyone have a good evening. Thank you.
Thank you. Have a good night.
Thank you and good night.